All right. Welcome back. Got a brief update on the Scofield versus Guillard case, the Idaho, well, the Tic Toc psychic being sued by the University of Idaho professor for defamation. Yeah, it's a whole thing. So it's been a little bit quiet. Trying to, speaking of quiet, trying to get my current setup. I seem quiet. I hope I don't to you guys. So yeah, this has been a little quiet, but just the same, I've fallen a few filings behind. They're not huge, earth-shattering filings, though, which is why I didn't rush out to cover them. Um, that being said, they they're enough that I've changed my mind, which I'm allowed to do. So I've said in the past that at the moment there's a there's an entry of default. So the defendant, the TikTok psychic, she didn't respond. So the Professor Schofield, through her attorneys, entered for a default judgment. And finally, even a long time after the default judgment was entered, the defendant finally responded. So I said, I think the court's going to find it excusable neglect because she was, she was a month late, not a year late, or and she's pro se, so that they go easy on pro se. Part of it, of course, is me being selfish, hoping for more easy content, more entertaining content, but yeah. But one of the two filings we have now missed. Well, that I didn't miss, I just have been slow, has made me change my mind. It just, the defendant is playing games. She's not taking this seriously. She's not litigating in good faith. So I I just I have a hard time extending grace if someone is intentionally not following the rules. Like an honest mistake, being late once and then saying, "Oops," that's one thing. But this I just find egregious, and it I think the judge is going to as well. So that being said, where are we? Well, as usual, we'll start with the docket. Um, so we left off at docket number 12. There has since been 13 and 14. So number 12 was a motion by Professor Schofield. The motion to strike uh, the counterclaim and answer to the complaint. So basically, the defense filed an answer and completely ridiculous counterclaims. And Professor Schofield saying, "Hey, court, don't even consider this. It's late. Throw it in the round filing cabinet. It's done." So we've got to look at uh, uh, of a filing that is usually glossed over, and I'm blocking part of it with my face. There we go. I don't want to scroll any further down because I don't want to show her address if I don't have to. So at the bottom of every filing, we have a certificate of service. Normally, we gloss over that because it's just it's a given. You've got to serve the other side. You say, "Hey, I served the other side. This is how I served them." So on ECF docket number 12, Professor Scofield, through her attorneys, filed this certificate of service. I hereby certify that on February 27th, 2023, I served a copy of the foregoing via overnight mail as follows to Ashley Guillard at her home address. Same address that the complaint was filed at, that was served at. So, yeah. And it bears mentioning, let's jump back to the docket. Speaking of which, um, what docket number was it? Number 8, the defendant, Ashley Yard, filed a motion to be granted access to CM, ECF, e-file access. So she wants to be able to file electronically, which, you know, it's a real pain in the ass for everyone involved if one of the parties isn't. Because if she has ECF access, then the plaintiff, Professor Scofield, everything she files herself through ECF is served through ECF to the defendant. But I don't know that she's been granted access yet. And it could be I I had to in order to be admitted to practice in federal courts. Well, before I could file in federal courts, I had to take a course by the federal courts on ECF, on the e-file system. Uh, so my understanding is pro se litigants have to take that same course. So it's possible that the defendant has not. And that's why she hasn't, to my knowledge, received access yet. Now, why is this all a big deal? Well, a couple of reasons, actually. So, looking at the motion to strike, the number 12, uh, looking in the docket, it says responses due by the 20th of March, which it's 11:11 p.m. on the 20th of March as I'm recording this, which means, well, yeah, it's Idaho. So, although bits of Idaho are Pacific, so it, although Boise, I think, is mountain, so it would be 11:11 in Boise. So it could be the response to this motion to strike has not been filed yet. But if it's filed by mail, they've got a couple days postage time, and it also could also be in the court because what we've seen with the answer with a few others is it doesn't get uploaded to the docket immediately. It doesn't get scanned by the court clerk. So it could be in already, but I don't know. So, point being, she could already be late with her response to the counterclaim or to the motion to strike. Sorry, and I don't know. She could be late already, but she might not be. If she has ECF access and the court just hasn't entered an order granting her access on the docket, then she is late, at least within an hour, within 57 minutes or 47 minutes. Sorry. Lawyers don't do math, even though, finance degrees. But um, so that being said, I've rambled long enough. This is why I think that the default judgment is going to be upheld. It's going to be granted. It, the fat lady is warming up. She may not be singing, but he's warming up. Um, so we have ECF number 13, plaintiff's notice regarding service. On February 27th, 2023, plaintiff filed a motion to strike defendant's answer, affirmative defenses, and counterclaims to complaint, ECF 12. Plaintiff included with that motion a certificate of service indicating that she sent the motion via overnight mail to the address listed for defendant on the docket. Previously, plaintiff used the same method of service to successfully serve her response to defendant's motion for relief from a judgment or order pursuant to Federal Rule of Civil Procedure 60B and her motion for default judgment, ECF 9 and 10. For the more recent motion to strike, however, plaintiff received a return from UPS stating receiver did not want, refused delivery, which is Exhibit A. We'll take a look at that in a minute. Accordingly, plaintiff submits this notice to correct its certificate of service of the motion to strike. Plaintiff will attempt other means of service and will notify the court of any updates. And that was filed on March 7th. So, why is this a big deal? Well, for starters, it's a big deal for the plaintiff because they put in a court filing, "Hey, we served the defendant." But now they're not eating crow, but they're correcting the record. They're saying, "Well, maybe we didn't serve the defendant, and here's why." So now we have a certificate of service, which, like I said, is usually just it's a necessity, but it's sort of a truism. It's there. And this one, I hereby certify that on March 7th, 2023, I served a copy of the foregoing plaintiff's notice regarding service via email as follows to Ashley Guillard at her email address. Um, then, if it wants to load, which is the mailing envelope, and it says right on the UPS sticker, return to shipper, reason for return, receiver did not want, refused delivery, original receiver, Ashley Guillard, UPS 3-day select. So this is a big deal because, like I said, she's playing games. Ashley Guillard is playing games. She's saying, "No, no, no, la 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 la. I'm not accepting service." Judges aren't, especially after you've been served the complaint. If you're receiving refusing service of a motion, ooh, I mean, I'd be sanctioned, and the defendant, she might not be sanctioned, but it could be worse because it could be, all right, yeah, I'm not going to sanction you. Like, I'm not going to put a monetary sanction, or I'm just going to grant the defendant or the plaintiff's motion. Give a default judgment. Done. That's what I'd do if I were the judge. But there's more. And that also reminds me, so I mentioned today is the deadline to respond to the motion to strike, at least according to the docket. The one of the problems with that, that's based on it it being served on that date. So it could be that that deadline, do, like it's still on the docket, but it's inaccurate because she wasn't served. Although the court might consider her as served because she's playing games. But finally, on March 14th, we had docket number 14, which is notice of defendant's acceptance of service. So, on March 7th, 2023, plaintiff filed her notice regarding service, alerting the court that when she tried to serve her motion to strike defendant's answer, affirmative defenses, and counterclaims to complaint via UPS overnight mail, plaintiff received a return from UPS stating receiver did not want, refused delivery. That same day, plaintiff sent her motion to strike, ECF number 12, and her notice regarding service, ECF number 13, to defendant using the email address, Gmail email address. On March 13th, 2023, defendant acknowledged receipt of the email and advised that she would submit a new mailing address to the court. And that stated March 14th, 2023. Certificate of service. I hereby certify that on March 14th, 2023, I served a copy of the foregoing notice of defendant's acceptance of service via overnight mail as follows to Ashley Guillard, and it was sent by UPS. That is a different mailing address. I'm not going to scroll down. I don't dox people, at least not intentionally. It is a different mailing address. So here's the thing, though. If it was the wrong address, why did UPS say refused? Recipient didn't want. It would be wrong address. But also, here's the other problem. If you move while you're being sued, you've got to update the court. You've I still smell shenanigans. I don't like shenanigans. No shenanigans. So That's where we are. I have a feeling, even if we do get the eventual default judgment that I am now predicting, I have a feeling we're in for a few more twists and turns on the path. With that said, I told you, short and sweet, not a whole lot to report, but I wanted to get it out before we get too much further behind. So, with that, thanks for joining me. Do all the YouTubey stuff, like, share, subscribe, and I will see you very soon, I'm sure. Bye bye.